Today we are going to see about the role of industrial tribunal under tough nut crack. That is from the new IR Code 2000 perspective. Because the new IR Code has specifically said about the settlement of industrial dispute by the conciliation or by the industrial tribunal. Now they remove the labor court. While we are dealing the number of cases pending before the National Law Grid information, that is about 35.74% of total cases pending at India, that is industrial dispute. In 2021, there are around 91,885 cases pending before more than 30 years in different high courts of India. The Law Commission also worried about this, and they expressed to bring some platform to settle the matter quickly and maintain the administrative of justice. In 2021, about 91,885 cases are pending for more than 30 years in different courts. That is the present scenario. And now we are going into the subject. Earlier, the settlement of dispute by the tribunal is appointed by the appropriate government under the matters which comes under the second schedule or third schedule, and also in section 2 only industrial tribunal constituted by the central government. That is the thing. Now in the IR code section 41, the appropriate government may by notification constitute one or more industrial tribunals for adjudication of industrial dispute, that is for performing other functions as may be assigned to them under this code. So tribunal is constituted by the central government, shall also exercise jurisdiction, power and authority conferred on the tribunal under the APF Act. And previously, under the second schedule, the matters dealt by the tribunal, wages include the periods and the mode of payment, compensatory and other allowances, hours of work and rest intervals, leave with wages and holidays, bonus, profit sharing, provident and gratuity, shift working, classification of trades, rules of discipline, rationalization, layoff, withdrawal of customary concession and privilege. But in court, the tribunal going to deal the matters discharge and dismissal of workmen, including the reinstatement or great relief to the workmen dismissed, illegality or otherwise of the strike or lockout, retrenchment of the workmen, trade union pictures. The other matters which are in the second schedule, which will be dealt by the some other bench considered by the appropriate government if at all needed. That is what said in the IR code. The powers of the tribunal has been specified in section 49(3). Their powers are utterance of the person examining his under oath, compelled to produce documents and the material object, issuing commissions for examining witnesses, other matters also, and investigation or inquiry made by tribunal national level shall be deemed to be a judicial proceeding within the meaning of section 193 and 228 of in IPC. And when we read subsection 4 to section 58, the appropriate government referred to the award or a part of the tribunal if the party bound by the award or the government itself consider that there has been a material change in the circumstances upon based. And this code, when it came into the picture, immediate after that, the labor court and other cases pending before other court will be transferred to tribunal. That is what mentioned in the section 58, that is subsection 4 to 58. And what are all their other powers? Granting adjournments, speedy settlement of dispute is the main objective for them. And the documentary and the evidences. The tribunals never bound by any rules or all the rules of the Indian Evidence Act. They adhere to principle related to proof of documents and claim for privileges. Section 123 and 124 of Evidence Act. As these may be based on public policy and natural justice. So, here they are trying to bring the justice by way of calling the parties and hearing the parties, asking them to appear before them and getting the materials, that's all. They never go into the evidences and all. And they also power to correct errors and review. So they can correct the error and review. And pleading modifications. Tribunals can allow the parties to modify their pleadings in the interest of justice. Continuing jurisdiction. The tribunal doesn't become the functus officio merely upon the making the award. It may certain circumstances consider matters arising out of the award. So they can go beyond the award also. And in the dispute, if it is pending for the long period, then they can give the interim relief. And now we are going to see how the code, that is this code under the industrial tribunal dealing the matters. The industrial tribunal will have two members. One is judicial and administrative, other is administrative. And the former presides two-member bench. Earlier it was two-member bench. The next member bench of two members will adjudicate on the matter relating to standing order, trade union dispute, legality of stoppages and individual employment terminations, etc., etc. in the second schedule. And the remaining cases, wages and others will be decided by the single member bench earlier. That is under the industrial dispute act. It is difficult to comprehend this classification. Two type of benches replace the labor court and industrial tribunal in the industrial dispute act. It is a poor rehash of existing system of compulsory adjudication. So now this has been replaced. The two-member bench must decide ID by consensus. Now twist comes. In cases where two members don't agree, their difference will be referred to the government, which will then add judicial member from the other tribunal, and three of them will decide the ID based on majority. So if someone denies whatever be the things and all, if they are not coming for consensus, then third member will involve their nose. The whole scheme is utterly convoluted and complex and will delay the adjudication proceedings. When we see the section 2A, empowers the government to specify the period within which the adjudicator is awarded to the government. This clause is missing in Industrial Relation Code. So this clause is not there. Inordinate delays is awaiting future of ID settlement systems in India, and the lawmakers didn't apply their mind on this important aspect. Now we are going to see the case laws relevant to industrial, how the industrial tribunal will see the industrial dispute cases in the recent past as well as in the past. When we see the very famous landmark judgment given by the Minerva Mills Limited Bangalore versus Union of India. In this case, the dispute is between the management and workers, which was further referred to industrial tribunal. But in this case, the government has changed the act, but tribunal asked the government not to change the act itself, because that is violating the fundamental rights. The industrial tribunal played a very key role in this case. In the newspaper India versus State Industrial Tribunal, in this case, the dispute between individual employee and the employer is not considered as an industrial dispute, but there is a common cause between the individual employee and others, then it will be treated as an industrial dispute. This is also the famous case law. And in the Lipton case, here Company was incorporated in the United Kingdom, which does not approximately 10% of business tea and groceries in the London, from where it is carries the business to the whole India, headquarters in Calcutta. The business includes manufacturing, processing and the packaging, all these things. But their office is at somewhere else. So the deports whether they will be treated as a separate unit or not in the respective case. But the tribunal said wherever the operation happened, there will be the dispute to be filed. That was the very famous case, Lipton case. And award is vitiated by the non-consideration of the material evidence. In the Orissa High Court, set aside the Industrial Tribunal wage award in IMFA case. Here, the DA and the basic has not fixed by considering the management plea as well as the studying the area in which the factory is situated, industrial classification, schedule of employment, all these things has not considered in this case, and the award has been given. But subsequent to that, management made the plea. Then Orissa High Court set aside the Industrial Tribunal wage award. So because here the tribunal straightaway jumped into the conclusion without analyzing the evidences. Then industry cum region principle must be based on actual facts, not just as a precedent. And the award must be based on evidence with security, not speculation on the assumptions. Tribunal failed to account for settlement, comparable industrial data and these things. So here there are major flaw did by Industrial Tribunal by not analyzing what was happened in the factory, what was the DA, what was the industrial study on wage, all these things has not been taken into consideration, and they just away gave the award. And Orissa High Court set aside the award given by the Industrial Tribunal in this case. Then Tribunal need not to follow strict technicalities of law in adjudication of industrial dispute. A tribunal is entitled to proceed based on oral and documentary evidence, which may not be strictly admissible in evidence under the Indian Evidence Act. The court have to decide only objectively, but the tribunal make the departure to decide even subjectively. Tribunal need not to follow strict technicalities of law in adjudicating the industrial dispute. Tribunal proceed based on oral and documentary evidence. The tribunal has the power to give adequate relief paid for the parties under the reference made to it. Here, when we see the dispute raised by the trade union or individual employee, their trade would be example. For example, they may ask for employment, they may ask for reinstatement with the back wages, or they may ask for arrears, scale of pay, all these things. But beyond that, the tribunal go beyond that. They will see the case and they may give in addition to that also. That is what here said in the Pottery Mastur Panchayat versus Perfect Company Limited. So they will see whether in one case they have given the tribunal has not accepted for the closure, but Supreme Court held that narrow question whether the closure was proper and justified. Tribunal by very terms of reference has no jurisdiction to go beyond the fact of closure. So they asked so many documents, records and all from the company in this case for the closure. But Supreme Court asked the tribunal to refer once again and see the background. The Industrial Tribunal has no jurisdiction to adjudicate any issue relating to salaries of the employees who were not a workman under the IDA. In this case, tribunal doesn't have the have to go into the act whether they are the workmen or not under the ID Act. They doesn't have that jurisdiction also in the case of Mohun Limited versus Mohun Staff Officers Association. The tribunal jurisdiction is limited to territory to which the dispute related and the area. Here, already we have seen this case. Again, I am repeating once again. Lipton Limited and versus their employees. The tribunal, the headquarters is Delhi, and the matter is referred to Delhi Tribunal, but their depot is also at Chennai. But the company has asked to conduct the dispute only to the Delhi, but the tribunal not accepted because the branches is also will be also considered as a respective state only. But the Supreme Court said that tribunal has the power only to their jurisdiction. That's what said in this case law. If question regarding validity of reference or the tribunal jurisdiction areas, the tribunal itself shall decide it. Finding of fact generally not within the scope of jurisdictional review unless they involve interpretation of the statute, which becomes the point of law. So they can interpret the statute what is in the law. They should not create any statute. That is the restriction is having under the industrial tribunal. Industrial tribunals are not strictly constrained by the formal rules of law. Their primary objective is to adjudicate and settle the industrial dispute effectively to maintain industrial peace and promote production. That is their objective. And they create new rights and the obligation. So, tribunal can raise the new rights for the parties and they can ask to agree for the existing terms and conditions. In the case of management of Masood hydroelectric project, and they can alter the terms of existing terms of employment in the case of work ban, and also have some incidental powers to them. Tribunal possesses implied incidental powers necessary to discharge their function effectively, do justice between the parties under the Grindleisman case. Scrutiny of management actions. Here, they can interfere if the management action is nullified, constitute an unfair labor practice, and is not bona fide exercise contractual power. Then they can go and ask for scrutiny of records, whether this dismissal is considered to be fair, there is no modified intention with the management while they are dismissing the employee. In this case, even during the probationary period is legitimate or merely the pretext. So they proved in the Brook Pond India case. Interference with the disciplinary action. If the disciplinary action is not fair, they can move their nose and they can struck the dismissal of the workman for misconduct. Non-interference with the managerial prerogatives. Here, if the company is making loss, they could not pay the bonus or they could not run the business. They can decide to close. So they should not ask the manager why you are closing. Like that, they should not raise the questions. And the fixation of wage structure. So the wage should be at par with the law or the industrial region wise or the fair wage to be governed. That is what they can go to that extent. But they should not ask this wage to be fixed to these employees. Like that, they should not say. That is what said in this case. And the revision of wages also. They should not ask this much wage to be given and all. They should see cost of living anomalies are here existing in the wage structure. In the case of English Electric Company Limited versus Management, tribunal ordered for reinstatement with the back wages for 153 workers who worked for 200 days. The management challenged the award in the High Court, but High Court denied and upheld the tribunal award by quoting the judgment referenced several key precedents that shaped the court approach. That's what they said. Establish the principles that tribunal have the wide ranging of powers to assess the evidence and are not bound by strict rules of evidence. And in the another, referring from the another case, emphasize the limit scope of judicial review, tribunal factual findings, and also refrain from the re-examination of the factual matrix. These are all some of the precedences in the English Electric Company Limited versus the manager. In the case of Tharakal Cooperative Milk Supply Society Limited versus their workman. Workman resigned by the force and withdrawn his resignation. So the management asked to resign and the particular worker. Then he has submitted his resignation. Subsequent to that, he resigned and the company has not settled the dues. The management did not appear, so also tribunal given the expert because the worker has approached the tribunal. Tribunal heard the matter. They summoned also. The management has not appeared. Then the tribunal given the ex parte award. The management filed the special leave petition, but the tribunal rejected. The court asked to review with the genuine grounds before the award. Here, the management said that they have some other work or they could not appear. Like that, they said. Because of that, the tribunal given the ex parte award. Subsequent to that, they filed a special leave petition before the tribunal to reconsider, and also they are ready to appear. But the tribunal has not accepted. But the court said that we can entertain these type of re-examination. Then you re-examine and submit the award and consider the award once again. And in the tribunal supremacy in the Rajasthan transport case, here the conductor has not issued the tickets for the 28 passengers. That was the charges. Then they issued a charge sheet and approved in the inquiry. Then he dismissed from the service. Dismissed the employee, filed the case, and the court asked to reinstate. But the company didn't listen and after many times approached. Because the workman knocked the doors of the company with the court order, but the company has not listened to that. Again the workman approached the tribunal to get the money. Then the management files a writ and the court denied it to entertain. Because industrial tribunal is empowered with the quasi-judicial power. That is the judgment given in the Rajasthan transport case. In the another case, Abadco case, transfer of company, the workman transferred from one company to another. The company was sold to another company. There is no absorption happened by the circular what they said. Then the workman filed the petition before the tribunal. Tribunal asked to take him on merits. Merits means regularization procedure, skill set and other thing. You can see and take as much as possible. Abadco did not reply but filed the writ before the. They have not accepted the tribunal award, but they filed the writ before the court. Company asked the court not to entertain appeal plea by tribunal. So the company filed a writ petition, writ appeal before the tribunal not to accept these type of plea. Court said that it's not like that. Justified tribunal role is with the ambit of ID Act. The tribunal role to settle the matter, not to create this one. That's why they asked the Abadco company to accept the whatever said by the tribunal and also trust the petitioner to see the award by its merit. That was the judgment given in the Abadco case. So, coming to the end of this presentation, I would like to say that all the HRs fraternity to maintain the proper records and adhere to the legal systems and go with the merits, and there should not be any prejudice and bias, and we should maintain the principles of natural justice while we are taking the disciplinary action and other thing. Surely the new IR code will help you to handle the dispute before with any union or with any employee. We can succeed from the case, because when we are seeing the tribunal's award in the presentation, surely help the employer, whoever wants to maintain the justice, surely they will win the case. Thank you. Please subscribe to Murali HR YouTube channel. My contact numbers are given here. If at all you want any support or anything, surely I will help you to approach. Thank you.